The ODPP was operationalized on 1st July 2011 and has since taken over 100% of prosecution services and charging decisions from the police. This has led to piling of cases, which has in turn created a backlog of cases which is both time and resource consuming.
The number of cases continue increasing, as can be seen in the statistics. Therefore, you find that the system is being clogged with too many cases.
There's therefore the need to have very many alternatives to prosecution.
One of the alternatives to full trial prosecution is plea bargaining.
Plea bargain is actually a recognized process in our system, as it is provided for under our laws.
Section 137A of the Criminal Procedure Code defines a plea agreement as an agreement entered by the defense and prosecution in a criminal trial. This is actually the process where the accused and the prosecution work out a mutually satisfactory disposition of a case subject to court's approval. It involves the defendant pleading guilty to a lesser offense or to one of the counts of a multi-count indictment in return for a lighter sentence than that possible of the grave charge. Plea bargaining may be entered into between the prosecutor and an accused person, where an accused person has been charged in court and at any time before the court passes judgment.
If an accused person would plead guilty to, would be charged today, plead guilty to, or agree to enter into a plea bargaining agreement with us tomorrow, you'd find that this is a case that can actually be concluded in the next 3 weeks.
There has to be the accused person pleading guilty to the charges.
If one agrees to plea bargaining, he forfeits some of his constitutional rights, especially the right to a full trial. The effect of the plea agreement is either to reduce the charge to a lesser included offense, or to withdraw a charge, or to stay other charges, or a promise not to proceed with other possible charges.
It is important to understand that the court would only adopt the plea bargaining agreement upon ensuring that it fits the law, that is Section 137 of the Criminal Procedure Code, and also fits the respect for the rights of the remaining rights of the accused person that have not been waived.
One of the benefits is, of course, reduction of the many cases that have been filed in court. So the backlog is reduced because not all cases have to go into trial. Victims also benefit because where there is need for compensation, plea bargain allows for compensation within a short period.
It has assisted us to decongest prisons. The other advantage is that it actually gives people who have been charged in court a second opportunity in life.
Resources used in plea bargain are very, very reduced because the process is shortened.
It helps especially in corruption cases where one of the conditions is a return or restitution of stolen funds. It helps therefore to recover the public funds that were stolen as a result of corruption.
Tunaahidi mashtaka yenye haki na usawa.